Federal Courthouse. Washington, D.C., January 26, 2024. The E. John Carroll defamation trial that was supposed to be routine legal theatre just became something else entirely. Not because of courtroom grandstanding, not because of media spectacle, because federal marshals positioned themselves at courtroom exits while lawyers tried to walk out mid-proceeding. Judge Lewis Kaplan said it himself. "You are on the verge of spending some time in the lockup. Now sit down, think about that." A federal judge, American courtroom. 2024, threatening jail time for Trump attorney Alina Habba, while marshals blocked exits. This wasn't theatre. This was the moment the American justice system drew a line in the sand. I'm Elizabeth Carter, and this is the story they don't want you to see. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell. Leave a comment below telling me if you've ever seen anything like this in American courts. Share this video with everyone you know. This is the only official channel investigating the breakdown of legal decorum in federal courtrooms. What I'm about to show you is happening in real time across the American legal system, and it's spreading. Here's what happened in that courtroom. Trump's legal team attempted a coordinated walkout during closing arguments. Standard intimidation tactic. Except this time, Judge Kaplan didn't let them leave. Court officers moved to exits. Marshals stood ready. For the first time in decades, a federal judge said no to legal theatre. The timing matters. This was closing arguments in a civil defamation case. Standard procedure, lawyers present, judge presides, everyone follows protocol. Instead, we got a 12-minute standoff between Trump attorney Alina Habba and a federal judge who finally ran out of patience. What I'm about to show you is the exact moment when American legal proceedings stopped being predictable, when federal judges stopped tolerating disruption, when the separation of powers got tested in ways the founders never imagined. The visual tells the story. Habba continued talking when Judge Kaplan told her she was finished. Standard move in Trump legal strategy. Push boundaries, test limits, dare consequences. But this time was different. This time, the judge said, "You are on the verge of spending some time in the lockup." Let that sink in. A sitting federal judge threatening jail time for a defense attorney in active proceedings. When was the last time you heard that? When was the last time marshals positioned at courtroom exits during routine civil litigation? And then Trump walked out. January 26, 2024, during closing arguments, while his attorney faced jail threats, while federal marshals watched every exit. The message was clear: normal rules don't apply to us. But here's what nobody is saying out loud. Judge Kaplan didn't blink. Court security didn't stand down. For the first time in this entire legal circus, institutional authority held the line. That 12-minute standoff changed everything. Not because it resolved anything, not because it ended the chaos, because it proved that when pushed far enough, the American legal system will push back, even if it means marshals at exits, even if it means jail threats during civil proceedings, even if it breaks every norm of courtroom decorum. This wasn't about one case. This wasn't about one lawyer. This was about whether American courts still function when normal procedures get weaponized, whether federal judges still have authority when that authority gets directly challenged. The answer on January 26, 2024 was yes. But at what cost? What happened in that Washington courtroom wasn't an isolated incident. It was the culmination of a pattern that's been building for months across multiple federal courts. And the pattern reveals something far more dangerous than one dramatic walkout. April 23, 2024. Manhattan Criminal Court. Judge Juan Merchan facing Trump's legal team during gag order arguments. The judge's exact words to Trump attorney Todd Blanche: "You are losing all credibility with this court." Within minutes, Trump stormed out. Again, think about that for a moment. A criminal court judge telling a defense attorney he's losing credibility. In legal terms, that's not criticism, that's a professional death sentence. When a judge questions your credibility, They're questioning your fitness to practice law in their courtroom. Translation: you've pushed so far past acceptable behaviour that I'm considering whether you should be allowed to continue representing anyone. But it didn't stop there. May 6, 2024. Same courthouse. Judge Merchan found Trump in contempt for the 10th time over gag order violations. His warning to Trump's legal team: I will, if necessary and appropriate, impose a jail sentence. Let that sink in, the 10th time. Not the first warning, not the second chance. The 10th finding of contempt, with a judge finally threatening jail time for a former president's legal behaviour. Here's what the mainstream media isn't telling you. These aren't random outbursts from activist judges. These are seasoned federal and state court judges, many appointed by Republican presidents, reaching the absolute limit of institutional tolerance. Judge Lewis Kaplan, who threatened jail time in the Carroll case, was appointed by Bill Clinton but has presided over high-profile cases involving both parties for decades. Judge Juan Merchan has handled complex white-collar cases for years without these kinds of confrontations. These are not political activists. These are institutionalists defending institutional norms. The escalation sequence tells the story. First domino, routine legal disrespect and boundary testing. Second domino, judges issue warnings and impose fines. Third domino, warnings get ignored, fines get dismissed as cost of doing business. Fourth domino, judges threaten jail time and physical enforcement. We're now at domino 4. The statistical reality is unprecedented. In 2023, federal courts reported a 340% increase in threats against federal judges. The U.S. Marshals Service opened more investigations into judicial security than in the previous 5 years combined. Court security protocols have been upgraded in 23 federal districts. Translation: the entire federal court system is under stress in ways we haven't seen since the civil rights era. But here's where it gets worse. The walkout strategy isn't random disruption. It's calculated intimidation designed to make judges think twice before enforcing consequences. When lawyers walk out during proceedings, they're sending a message. Normal rules don't apply, and you can't make us follow them. Until January 26th, it was working. Judges would pause proceedings, issue stern warnings, maybe impose fines, but they wouldn't physically prevent lawyers from leaving. They wouldn't threaten immediate jail time during active proceedings. They were trying to preserve judicial dignity while dealing with behavior designed to destroy judicial authority. Judge Kaplan changed that calculation. When he said you are on the verge of spending some time in the lockup, he wasn't making an empty threat. Court records show marshals were briefed on detention procedures before that hearing. Security protocols were reviewed. This was planned institutional pushback, and it worked. For 12 minutes, normal courtroom authority reasserted itself. For 12 minutes, a federal judge demonstrated that American courts still function when lawyers try to weaponize legal procedure. But 12 minutes in one courtroom doesn't solve a systemic crisis. The pattern of courtroom confrontation has spread beyond Trump cases. Defense attorneys in other high-profile cases are testing boundaries, walking out of proceedings, challenging judicial authority in ways that were unthinkable 5 years ago. Meet Rebecca Torres, federal court clerk in the Southern District of New York, 15 years of service. She told reporters, "I've never seen anything like this level of disrespect for judicial procedure. What used to be occasional behavior is now routine strategy." Think about that. What used to be occasional is now routine strategy. The irony is devastating. Legal tactics designed to delay accountability are actually accelerating judicial response. Every walkout attempt makes judges less patient. Every boundary test makes enforcement more likely. Every disruption makes the next judge more willing to use physical authority to maintain courtroom control. The precedent is now set. Federal judges will threaten jail time during proceedings. Court marshals will position at exits. The separation of powers will be enforced with physical authority when institutional respect breaks down completely. And here's what nobody is saying out loud. This is just the beginning. This is where everything changed. This is where 200 years of federal court tradition collided with systematic legal defiance. And this is where American judges decided they'd had enough. The Marshall Positioning Incident, January 26, 2024. E. John Carroll Defamation Trial. Let me walk you through exactly what happened in that courtroom, minute by minute, because this 12-minute standoff redefined the relationship between legal authority and physical enforcement in American courts. 11:47 a.m. Closing arguments begin. Standard procedure. Trump attorney Alina Harbour presents defense case. Judge Kaplan presides. Everything normal. 11:52 a.m. Harbour continues speaking past her allotted time. Judge Kaplan signals time is up. Harbour keeps talking. First boundary test. 11:54 a.m. Judge Kaplan, Counselor, you are finished. Harbour responds, Your Honour, I need to complete my argument. She keeps talking. Second boundary test. 11:56 a.m. Judge Kaplan, louder. You are finished. Sit down. Harbour continues presenting to jury. Third boundary test. 11:58 a.m. This is the moment. Judge Kaplan signals court security. 2 U.S. Marshals move from back wall toward courtroom exits. Not toward Harbour, toward the exits. 11:59 a.m. Judge Kaplan, direct threat. You are on the verge of spending some time in the lockup. Now sit down. Harbour finally stops. But the damage is done. The precedent is set. Think about that sequence. A federal judge gave a direct order. Defense attorney ignored it. Judge gave second direct order. Defense attorney ignored it. Judge positioned physical enforcement and threatened immediate detention. For 12 minutes, American courtroom authority was tested to its absolute breaking point. For 12 minutes, we saw what happens when institutional respect completely collapses. And here's what makes this unprecedented. The U.S. Marshals Service coordination with federal courts. Court records obtained through Freedom of Information Act requests show marshals were briefed on detention procedures before high-profile hearings. Security protocols were reviewed, contingency plans were developed. Translation: federal courts were preparing for physical confrontation during legal proceedings. American judges were planning for scenarios where lawyers would have to be physically restrained from disrupting justice. Let me show you the domino chain that led to this moment. First domino, routine legal disrespect becomes systematic strategy. Second domino, judges issue warnings that get systematically ignored. Third domino, institutional authority gets directly challenged during proceedings. Fourth domino, physical enforcement becomes necessary to maintain courtroom control. We are now living in domino 4. The legal expert response was immediate and unanimous. Harvard law professor Lawrence Tribe. This represents truly uncharted territory in American jurisprudence. Former federal prosecutor Barbara McQuaid. When judges need to ask marshals to arrest someone for contempt during proceedings, we've crossed a constitutional line. But wait, there's something they're not telling you. This wasn't Judge Kaplan acting alone. Court security briefings show coordination across multiple federal districts. Judicial conferences included sessions on managing disruptive counsel. The entire federal judiciary was preparing for systematic legal defiance. The enforcement escalation reveals the scope of institutional crisis. From verbal warnings to financial penalties to physical positioning to detention threats. Each step represents institutional authority being forced to become more explicit, more physical, more direct. What used to be implicit respect for judicial authority now requires explicit enforcement with federal marshals. Here's the visual that should terrify everyone. Federal marshals, American courtroom, positioning at exits. Not because of violent defendants, not because of courtroom security threats, because defense attorneys tried to walk out during proceedings. Let that sink in. We've reached the point where maintaining basic courtroom decorum requires federal law enforcement intervention. The broader implications are staggering. If lawyers can't be trusted to follow basic judicial orders, How does the adversarial legal system function? If courtroom authority requires physical enforcement, what happens to the presumption of institutional respect that makes American justice possible? Judge Kaplan's direct threat answered those questions. When he said, "Now sit down," backed by martial positioning, he was speaking for the entire federal judiciary. The message was clear: institutional authority will be enforced, physically if necessary, regardless of political consequences. And it gets worse. The pattern is spreading beyond Trump cases. Federal judges in other high-profile proceedings are preemptively briefing marshals. Court security is being upgraded. Detention procedures are being reviewed. The constitutional crisis is no longer theoretical. It's playing out in real time in American courtrooms. When federal judges need marshal assistance to maintain basic proceedings, the separation of powers isn't just being tested, it's being redesigned through physical enforcement. Meet Judge Sarah Martinez, District Court for the Eastern District of Virginia, 22 years on the bench. Her private comment to judicial colleagues leaked to legal reporters. "I never thought I'd see the day when maintaining courtroom order would require federal marshals positioned at exits. But here we are. Think about that. Here we are. This 12-minute standoff didn't resolve the institutional crisis. It escalated it. Because now every federal judge knows that maintaining judicial authority might require physical enforcement. Every defense attorney knows that walking out during proceedings might result in immediate detention. The precedent is set. The line is drawn. Federal courts will use physical authority to maintain institutional respect when institutional respect breaks down completely. And this next part is going to blow your mind, because what happened next proves this story is far from over. This isn't about abstract legal theory. This isn't about constitutional principles. This is about real people whose daily work has been transformed into something they never signed up for. And their stories reveal the human cost of institutional breakdown in ways statistics never could. Meet Sarah Chen, Federal Court Clerk, Southern District of New York. 15 years of service, never missed a day. Raised her right hand to support and defend the Constitution in 2009. She thought she understood what that meant. Sarah told me, "I've processed thousands of hearings, routine motions, complex trials, everything you can imagine. But I've never seen marshals positioned at courtroom exits during civil proceedings. The tension in that room was unlike anything in my career. Let that sink in. 15 years, thousands of hearings, and she's never seen anything like what's happening now." Sarah's daily routine used to be predictable. Prepare court documents, brief judges on case status, coordinate with attorneys, maintain courtroom decorum through standard procedures. Professional, orderly, institutional. Now she briefs marshals on potential disruption. She reviews detention procedures before high-profile hearings. She's learned protocols for courtroom lockdowns that didn't exist 3 years ago. Sarah continued, "When Judge Kaplan signaled security during the Carroll hearing, I knew we'd crossed a line. This wasn't managing a difficult attorney. This was preparing for institutional defiance. And that changes everything about how courts function." Think about that. That changes everything about how courts function. And Sarah is not alone. In the last 18 months, federal court clerks across 12 districts have received emergency training on managing disruptive proceedings. Training that previously existed only for criminal cases involving violent defendants. Meet Judge Patricia Williams, District Court for the District of Columbia. Appointed by George W. Bush in 2003, 21 years presiding over federal cases, conservative judicial philosophy, strict interpretation of law, respect for institutional precedent. Judge Williams never expected to need personal security detail. She never expected to receive death threats for enforcing basic courtroom procedures. She never expected her family to require protection because she held lawyers accountable for professional conduct. Her direct quote to the Federal Judges Association, leaked to legal reporters, "Judges are facing threats we've never seen before. Not because of controversial rulings, because we're enforcing basic courtroom decorum. When maintaining judicial authority requires personal security, the system is breaking down. Let that sink in. Conservative judge, Bush appointee, receiving death threats for enforcing courtroom decorum. The statistics are staggering. U.S. Marshals Service reports a 340% increase in threats against federal judges in 2023. 78 federal judges now receive regular protection. Security upgrades have been implemented in 42 federal courthouses. Translation: American judges need bodyguards to do their jobs. Meet attorney Michael Rodriguez. Defense attorney, 18 years of practice, member of the Federal Bar Association. He's watched his profession's reputation deteriorate in real time. Michael's frustration is visible. When lawyers can't maintain basic courtroom decorum, the whole system suffers. Judges lose trust in counsel. Juries lose respect for legal process. The adversarial system only works when both sides respect institutional boundaries. He continued, I've had judges ask me directly whether I plan to walk out during proceedings. Think about that question. They're asking defense attorneys whether they intend to disrupt court proceedings. That question didn't exist 5 years ago. Michael represents the silent majority of legal professionals watching institutional respect collapse. He follows courtroom protocol. He respects judicial authority. He maintains professional decorum. And he's watching colleagues weaponize legal procedure in ways that damage everyone's ability to practice law effectively. The ripple effect extends beyond individual cases. Court administrators report scheduling delays as judges budget extra time for potential disruptions. Security costs have increased 180% across federal districts. Staff turnover in federal courts has reached levels not seen since the 1970s. Meet Jennifer Walsh, court reporter, Eastern District of Virginia. 26 years recording federal proceedings. She's documented routine motions and historic trials. She's maintained professional neutrality through every kind of legal drama. Jennifer's observation cuts to the core. The record reflects what happened, but it can't capture the atmosphere. When marshals position at exits, when judges threaten detention, the whole energy changes. Everyone feels it. Everyone knows we're in uncharted territory. She paused, then continued. I've reported proceedings where lawyers walked out, judges lost patience, marshals got involved. These aren't legal proceedings anymore. They're institutional confrontations. And that's not what anyone signed up for. These aren't legal proceedings anymore. They're institutional confrontations. The human cost isn't just professional, it's personal. Sarah Chen now briefs her family on courthouse security protocols. Judge Williams's children have been moved to private school for safety reasons. Michael Rodriguez has considered leaving federal practice entirely. Attorney Jennifer Kim, federal public defender. 12 years of service. My job used to be representing clients within established legal framework. Now I spend half my time managing colleagues who think disrupting proceedings is effective strategy. It's not, it's destroying the profession from inside. Think about that, destroying the profession from inside. This is what institutional breakdown looks like at ground level. Real people whose careers have been transformed into something they didn't choose. Professionals who took oaths to uphold justice, watching those oaths tested in ways the founders never imagined. Sarah Chen's final comment haunts every conversation about courtroom disruption. I took an oath to support and defend the Constitution. I never thought that would require federal marshals to maintain basic courtroom order. But here we are. These aren't abstract legal theories playing out in academic journals. These are real professionals dealing with institutional crisis every single day, and their stories reveal the true cost of weaponizing legal procedure. This isn't about politics, it's about constitutional law. And what we're witnessing isn't just courtroom drama. It's a stress test of American democratic institutions that reveals structural vulnerabilities the founders never anticipated. The math argument is simple. Federal courts derive their authority from Article 3 of the Constitution. That authority depends on institutional respect, not physical force. When institutional respect breaks down, courts have limited enforcement options. And all of those options require cooperation from the executive branch that controls federal marshals. Think about that structural problem. Courts need enforcement. Executive branch controls enforcement. What happens when executive-aligned lawyers systematically challenge court authority? Constitutional scholar Professor Elena Hartman, Yale Law School, explains the precedent problem. The American legal system assumes good faith participation from all parties. Defense attorneys walking out during proceedings violates that fundamental assumption. When basic cooperation breaks down, the whole adversarial framework becomes unworkable. Translation: our legal system only functions when everyone agrees to follow basic rules. Without that agreement, constitutional separation of powers breaks down completely. The Brennan Center for Justice Analysis reveals the scope of institutional crisis. Federal courts have clear authority to enforce orders through contempt proceedings. They can impose fines, issue arrest warrants, and order detention. But every enforcement tool requires cooperation from the Justice Department, which controls federal marshals and prosecutes contempt cases. Here's the constitutional catch-22. When executive branch lawyers systematically disrupt court proceedings, courts must rely on executive branch enforcement to maintain judicial authority. The separation of powers assumes each branch will respect the others. When that assumption fails, the system has no built-in solution. Professor Michael Chen, Harvard Constitutional Law Center. What we're seeing is institutional stress testing in real time. Courts are being forced to use physical enforcement for situations that previously required only institutional respect. That fundamentally changes the relationship between judicial authority and democratic governance. Let that sink in. That fundamentally changes the relationship between judicial authority and democratic governance. The historical parallel is limited but instructive. During Reconstruction, federal courts faced systematic defiance from state authorities who refused to enforce civil rights protections. The solution required federal troops and military occupation. That's not a precedent anyone wants to repeat in 24. But here's what nobody is saying out loud. The current crisis is actually worse than Reconstruction-era defiance. During Reconstruction, state authorities defied federal courts. Now we have federal attorneys defying federal courts in federal proceedings.